Labor law deals primarily with unions and unionized employees, although federal labor statutes protect non-unionized workers as well. Federal labor law applies to private sector employees, whereas public sector labor law is mostly a matter of state law. This course focuses primarily on private sector employees. Throughout the 19th and early 20th centuries, employers prevented collective worker activity by using the law and the courts. Courts enjoined strikes, and employers deployed antitrust law to resist unionization. To control the growing labor management conflict accompanying industrialization, Congress created a national framework for employee collective action and labor management relations. The most significant statute and the bedrock of modern U.S. labor law is the National Labor Relations Act, also known as the NLRA. The modern NLRA began life as the Wagner Act in 1935. The statute expresses a policy of preserving industrial peace through collective bargaining. The Act's fundamental provisions remain the same today. Generally, Section 7 guarantees workers the rights to organize themselves, to form unions, and to engage in other concerted activities. Section 8 prohibits certain employer actions, referred to as unfair labor practices, or ULPs, that interfere with or punish employees for exercising their Section 7 rights. Section 9 creates an election system through which employees may choose a union to represent them. The most significant amendment to the NLRA was 1947's Labor Management Relations Act, also known as the LMRA, or the Taft-Hartley Act. This act added restrictions on unions that parallel the constraints on employers. It also amended Section 7 to explicitly recognize an employee's right to refrain from joining a union.